It is my great professional and in this case personal pleasure to introduce to you Howard M. Levine, partner at Sussman Shank, a major commercial transactional and litigation firm in Portland, Oregon. Howard is a graduate of Monmouth State University or college, whatever, and the University of Toledo College of Law, where he served on the law review. In practice, he has clerked for a U.S. bankruptcy judge in Portland and represented nearly every conceivable sort of bankruptcy litigant that you can imagine, including creditors with recoupment and set-off claims, defendants in preference litigation, debtor in possession, indenture trustee, secured creditors, Chapter 11 asset purchasers, trustees of post-confirmation trusts. If you are at all aware of the many procedural pieces of bankruptcy litigation, he's done them all. He is most noted for his work in the bankruptcy litigation involving the Portland province of the Society of Jesus the Jesuits and the Portland Diocese or Archdiocese? Archdiocese, both involving claims of child abuse. Generated enormous amounts of litigation, very big money, and so one of the most significant pieces of litigation, bankruptcy litigation in recent history. I could read you a list of his best lawyer and most recognized lawyer and awards and honors. It would take a while. I won't. I can tell you that he is published widely in continuing education journals, given numerous lectures. And I have to conclude on a personal note. Howard's story begins in New York, as so many do. He made a brief stop off in Toledo to go to law school. This was a time when there were many more law students than there were law schools. And so we were very lucky to get tons of extremely talented young students from very far and wide, principally the East Coast. But for me, it becomes even more personal because in 1976, his first year as a baby first-year law student was my first year as a baby first-year law teacher. And so, after 6,000 or 7,000 law students, they all kind of run together, but you never forget your first. Howard M. Levine.
Well, I want to thank Professor Richmond for such a nice, warm welcome, a little bit overstated, but very nice nonetheless. It is true that he was my very first law professor, very first day, September of 1976. And it's hard for me to know who was more nervous that day, whether it was me as a student, having watched the paper chase, expecting to be called on by Professor Richmond, or Professor Richmond not knowing quite what to do as he stood in front of a class of students who were waiting to hear him express all the knowledge that he thought he had, or we thought he had. But he did good. He did good, and as I told him last night at dinner, he had a tremendous influence on me personally and on my career, and I'm deeply indebted to him for all of that. I want to thank the law school for having me here, Dean Steinbach and Bill Richmond, of course, and Rachel Phipps for making all of this happen. It was very, very kind of her to expend the time and the effort to do that. Anyway, what I'm here to talk about are archdiocesan bankruptcies, and this is an area that has evolved over the last probably 10 or 12 years. And as Bill mentioned, we represented the Portland Archdiocese in 2004 in its Chapter 11 case. And to give you some context, the Portland Archdiocese covers Oregon from the Pacific coast to the eastern slopes of the western slopes rather, of the Cascade Mountains, and from the California border down to, or up to Washington State. And there are about 350,000 Catholics in the Portland Archdiocese, and they are in 124 parishes. A few years later, we represented the Society of Jesus Oregon Province, which is one of 10 geographic provinces in the United States that the Jesuits have. And it was the first religious order to file Chapter 11 in the United States. And I can tell you that these cases were by far the most interesting and professionally challenging cases in my career. In the Archdiocese case, which again was the first one to be filed, we were the snowplow that had to find the road. There was no road to be found. There were no signposts to help us. And we had to figure out how to get through Chapter 11 and get out of Chapter 11 and literally save the Archdiocese of Portland. Since 2004, there have been at least 10 other archdiocesan bankruptcies, including the Archdiocese of Milwaukee, Wisconsin, Gallup, New Mexico, Wilmington, Delaware, Spokane, Washington, and Fairbanks, Alaska. In the Portland case, we had Judge Paris, Elizabeth L. Paris, who was our judge. And for a local connection, Judge Paris is the only bankruptcy judge now serving as a mediator in the Detroit Chapter 9 case. She was appointed by the Federal District Court judge to serve in that capacity. But to start, I think we're going to take a little quick trip through Catholic school. I don't know how well you can read this, but what I'm pointing up there is we start with canon law, the law of the Catholic Church. Canon law is the oldest continuously functioning legal system in the world. It goes back many, many centuries. And according to the manual on canon law, what it says is this: canon law is the system of laws and legal principles made and enforced by the Church's hierarchical authorities to regulate its external organization and government, and to order and direct the activities of Catholics towards the mission of the Church. And this becomes very important in these cases. Canon law rules were codified in the Revised Code of Canon Law and promulgated by Pope John Paul II in 1983. So let's start with some important terms. What is a diocese or an archdiocese? A diocese is basically a territory, geographic territory. Smaller ones are dioceses, larger ones are archdioceses, like the Archdiocese of Portland or the Diocese of Toledo. A bishop or an archbishop is the person in charge of a diocese or an archdiocese. Now, I don't know how well you can read this, but basically what this says up here is a diocese, which is a collection of people for a religious purpose recognized by the Church, is a separate juridic person under canon law. And a separate juridic person can own and administer its own property. So under canon law, what this all means is a parish, a separate juridic person, can own and administer its own property under canon law. And this is very important because we have this set of religious rules, these laws, if you will, that govern the internal operation of the Catholic Church for religious purposes. And that includes rules that govern the ownership of property. So what happens if canon law, the law of the Catholic Church, conflicts with civil law? For example, what if a parish, a separate juridic person that under canon law owns and administers its own property, doesn't follow civil law rules for how that property is held? So for example, a parish which owns a rectory or a chapel puts the title to the chapel or the rectory in the name of the archdiocese. Who owns that property? Is that property owned by the archdiocese or the diocese? Or is it owned by the parish? On the deed it says the diocese owns it, but canon law says the parish owns it. And I'm going to talk about how that conflict plays into these cases in just a few minutes. But why would a diocese or an archdiocese file Chapter 11? Well, the main factor are obviously the sex abuse cases and the sex abuse scandal that we've all read about. But I'm not here to talk about that part of these cases today. What I want to talk about are some of the issues in the diocesan Chapter 11 cases and how they get resolved. So, how do you approach one of these cases? Well, from a strategic and analytical standpoint, the best way to look at these cases is like a mass tort case, because that's really what they are. It's like the asbestos Chapter 11 case of Johns Manville, or breast implant cases involving Dow Corning. In those cases, they had thousands of known existing claimants, people with cancer, and unknown amounts of liability. They had unknown claims in unknown amounts from an unknown number of people. and they faced unknown, and they didn't know how many claims might arise in the future, because people who have undiagnosed diseases don't necessarily have claims until they're diagnosed. And they needed to come up with a system, a solution, to allow them to deal with the cost of litigation, the uncertainty of the liability, and to be able to resolve the future claims in a way that allowed them to stay in business, because those claims might arise in 50 or 60 years. And similar to the other mass tort cases, the Catholic Diocese faces very similar situations. There are known sex abuse claims where a claimant has filed a lawsuit, has made a demand, has approached the diocese and say, I was abused by Father so-and-so at this particular point in time in history, and I want to be compensated for it. There are unknown abuse claims where a claim may exist, an incident may have occurred, but the claimant hasn't come forth and told the diocese or made a demand or filed a lawsuit. And there are future claims. A future claim is an unknown sexual abuse claim that may arise in the future, but currently not known to the claimant. So a typical future claimant would be a minor, an adult who was abused as a minor and has repressed the memory of the event and has not made the connection between the event and damages. In other words, they have a claim, but they don't yet know it. And that's similar to the undiagnosed cancer victim in the other mass tort cases. But what Chapter 11 does, though, is it provides a mechanism to protect the debtor from future claims, to resolve the current claims, and to compensate people who do have claims that arise in the future. So the second issue that comes up in Chapter 11 cases is insurance. Insurance is often, but not always, the biggest asset in a diocesan Chapter 11 case. But what happens when the insurance companies say, and it's hard to believe insurance companies ever say this, we're not going to pay the claim. It's not covered. You've exhausted your limits. And the diocese has many, many, many claims still yet to be resolved. So where's a good place to get all the insurance coverage issues resolved in one place? The third big issue is, what property does the diocese own? And that can involve hundreds of millions of dollars. In the Portland case, as I said, 124 parishes, we had about 600 parcels of real property scattered in the Archdiocesan territory. So where's the best place to resolve that? So we have claims, including future claims, insurance disputes, and property of the debtor. So how does Chapter 11 help that? Well, Chapter 11 helps this way. It brings the debtor, current creditors, unknown future creditors, insurers, all together in one place with a legal mechanism, which is the bankruptcy code, overseen by one judge to solve the complex problems and help find a global resolution. And bankruptcy court's really the only place that can occur. Okay. So because of the confluence of all these issues, religious issues, civil issues, the First Amendment, federal non-bankruptcy law like the Religious Freedom Restoration Act, or RFRA, the bankruptcy code, and a myriad of other areas of law, these all truly collide in the bankruptcy court. So with that backdrop, what are the immediate precipitating factors that cause a diocese to decide to file bankruptcy? Well, often, but not always, it's the pendency of a very large case about to go to trial. Sexual abuse cases involve very, very big dollars. A diocese may be concerned that if a sex abuse case goes to trial in front of a jury, that the award is going to be too large, and that award could either set the bar for future claims or make it impossible for the diocese or its insurers to pay other claims that may come along later. In the Portland case, we filed on the eve of trial where there was a claim for $125 million. The San Diego Diocese and the Wilmington Diocese also filed on the eve of trials. The second immediate factor is, what is the property of the estate? What does the debtor own? What does the diocese own? And again, a parish, separate from the diocese, they're both separate juridic persons. Under canon law, the parish owns its own property, the diocese owns its own property. But under state law, a parish's corporate structure may be different than what canon law says it should be. Which one controls? Here's typically the way it plays out. The two typical situations in the United States is you have a parish, which is a separate non-profit religious corporation, properly incorporated under state law, and it has property that it acquired, and title to the property is in the name of the parish. St. Elizabeth's Parish, comma, a non-profit religious corporation, owns the property on the deed. And that's consistent with both canon law and civil law. The situation we had in Portland and in many other dioceses is that parishes are not separate corporations under state law. Legal title to the property is held in the name of the diocese. So who owns the property? Is the court required to follow canon law and conclude that the parish owns the property because as a separate juridic person it owns and acquired its property and therefore it belongs to it? Or can the court just disregard canon law and go to state law and say, well, under the state statutes, the deed holder is presumptively the owner, and since the parish isn't a corporation and it can't hold property, it must be that the diocese owns it. Or, another situation, is legal title is held in the name of the diocese, but is the property held in a charitable trust for the benefit of the donors who gave the money to acquire the property, or the parishioners in the parish? They're the folks that raise the money to go build the parish on property perhaps a parishioner donated for the parish. And so in that case, wouldn't that be a charitable trust? And then the charitable trust assets are not available to pay claims against the Archdiocese because they're protected under state law? Well, that's where the First Amendment comes in. Does canon law supplement, supplant civil law, or is it irrelevant? If the bankruptcy court rejects canon law and applies only state law to determine property ownership, would the bankruptcy court be arranging the polity of the church if it took parish property away to pay the debts of the diocese? Again, separate juridic persons, separately owned property under canon law, but civil law maybe not. So let's look at how religious law appears in some of the statutes, and I can speak to Oregon because we dealt with this issue. In Oregon, and I don't think Ohio has this by statute, the diocese is what's called a corporation sole. Can you guys see this okay? Okay. In a corporation sole, it's really the incorporation of the office of the bishop or the archbishop, and the bishop is the sole director. And you can see, in conformity with the Constitution, canons, rules, and regulations, a religious denomination can form a corporation under this section. Okay, now I'll read that one. Well, you can't see it because you can't, you're older than some other people here. You do. We go to the same barber, don't we? Anyway, under ORS 65-357, the bishop, and I'll read this to you, it says, general standards for director. I can read it here. A director shall discharge the duties of a director, including the director's duties as a member of a committee in good faith, with the care an ordinary prudent person would exercise, and in a manner the director believes to be in the best interest of the corporation. In discharging the duties of a director, a director is entitled to rely on information, opinions, reports, or statements, including financial statements and other financial data, if prepared or presented by, in the case of a religious corporation, religious authorities and ministers, priests, rabbis, or other persons whose position or duties in the religious organization the director believes justifiably reliance and confidence, and whom the director believes to be reliable and competent in the matters presented. So the bishop, in being the sole director of the corporation sole, why can't he rely on canon law? After all, canon law is a reliable religious authority. And the bishop is basing his entire operation of the church, of the diocese rather, on canon law. And what about this in Oregon? If the religious doctrine or practice governing the affairs of a religious corporation is inconsistent with the provisions of this chapter on the same subject, religious doctrine or practice shall control to the extent required by the U.S. Constitution or the Constitution of the State of Oregon. Doesn't that give great deference to the bishop's right to rely on canon law to make decisions and to operate his diocese? The bankruptcy court in Portland said no. It applied neutral principles of law to determine property ownership, citing to the Jones v. Wolf case by the U.S. Supreme Court. The court held that canon law does not govern property ownership in the secular world. Or as Judge Paris liked to say from time to time, I don't do canon law. The bankruptcy court rejected the application of these statutes that I cited to you and concluded that parish property belonged to the Archdiocese because the diocese was on the deed. But the Archdiocese never bought this property. It didn't pay for it. The property was purchased by parishes through donations and fund drives and building drives over decades, and many decades, sometimes going back more than 100 years. The Portland Archdiocese is one of the oldest archdioceses in the United States. It was founded in 1846. It has a very long and rich history. As part of the litigation I was involved in and part of the discovery I had to do, I spent months reviewing tens of thousands, literally tens of thousands of pages of old parish records. They came in boxes, and some had plastic over them, and some were yellowed, and these went back to the 1800s. And what I concluded from reading all this stuff was that parish real property was acquired through the personal efforts of members of a parish over time. Whether it was fund drives, building drives, literally spaghetti feeds. I had spaghetti feed ticket receipts that I would look at. Land donations, volunteer masonry, carpentry work, all contributed by parish members. But when we made the argument, the court rejected it, concluding that because the parish was part of the diocese, it could not be a beneficiary of a trust where the diocese was the trustee. Ultimately, the court disregarded the separateness of the parishes under canon law and concluded the parish property belonged to the diocese. Now, I'm sure you've all heard or at least read about the Religious Freedom Restoration Act of 1993, RFRA, and the recent Supreme Court case involving the Hobby Lobby case and contraceptive mandate in the Affordable Care Act. We argued on summary judgment that under RFRA, if the bankruptcy court were to deprive the parishes of their property, it would substantially burden their ability to practice their faith. On summary judgment, the bankruptcy court couldn't resolve that question because there weren't enough facts and deferred it to trial. But now, today, and that was 2005 or so, I sort of wonder in light of the Hobby Lobby case whether or not that issue is much more difficult for the court today than it would have been back then. Well, in addition to real property, there's other assets of the diocese that are at risk, and that's money and trust. Typically, there's two types of donated funds in Archdiocese, and those of you who are Catholic and go to church, you understand what I'm talking about. There are funds donated to a diocese for general diocesan purposes, where there's no special purpose for that particular donation, just a general donation that goes into a general fund. The other is funds donated for a specific charitable purpose. So at the diocesan level, for example, dioceses will from time to time have fund drives to raise money for things like a cemetery fund, perpetual care, long-term health care for retired priests, or other things that are very specific depending upon the needs at the time. Or people just simply donate funds and say, I want to donate money to the priest's retirement fund, or I want to donate money to the cemetery fund, or whatever the purpose might be for the diocese. And shouldn't the conditions donors place on those funds be honored? Are funds donated for a specific charitable purpose available to pay sexual abuse claims at the diocese level? Well, the answer to that probably is they are protected, and those funds shouldn't be used for that purpose. And there's an interesting Toledo connection to this. I'm trying to bring all the Toledo connections I can to this case. One of the most important cases on this subject is a case out of Toledo. It's called In re Parkview Hospital, and it dealt with the question of restricted gifts. And that's, for those interested, it's a 211 BR 619. But assume for today that general diocesan purposes, where money is just sent to the diocese for general purposes, is available to pay tort claims. But what happens if the diocese commingles the general funds with all these special purpose trust funds? because the typical practice of dioceses around the country is to use what are called PIAs, pooled investment accounts, where they take all the funds that they have, they invest them together, but they account for the trust funds separately from the operational funds. And this raises the question, can those funds that are donated for a special purpose be traced? Can you find them? Can you prove that those are actually not commingled to the point that they're indistinguishable from the operating funds? And that applies something called the lowest intermediate balance rule, which you may or may not have learned about yet, but you probably will. And there's two different outcomes. In the Diocese of Wilmington case, where the funds were commingled, Judge Sanchi, the federal bankruptcy judge at Delaware, ruled that the commingled funds, that the trust funds could not be traced through the commingled funds the way they did their accounting, and the diocese lost all of the trust funds. In the Archdiocese of Milwaukee case, the opposite outcome occurred because the funds weren't commingled and they were separated and they were preserved. So the lesson here is, whether it's a church case or any other kind of case, you never commingle trust funds with non-trust funds, even if you think you have the greatest accounting system in the world to keep track of it. It's just not worth it. There's way too much at risk. I touched on insurance coverage a minute ago. It's a big issue. Normally, a commercial general liability policy that a diocese or any business has are what are called occurrence policies. The policy has to be in place at the time the occurrence occurs, not at the time the claim is made. And coverage is usually for negligence, not for intentional torts. And policies have a per occurrence limit, and they have an aggregate limit, total amount to be paid under a policy in a year. Say $100,000 per occurrence with an aggregate of $1 million. Many of the old policies did not have a specific exclusion for sexual abuse claims, whereas today most policies do exclude sexual abuse claims unless you purchase a separate rider to cover them. I want to throw this at everyone here. Anyone want to guess when the earliest known date of pre-sexual abuse in a diocesan Chapter 11 case was alleged to have occurred? Anybody have a thought when that might have happened? Pick a year, any year. 1938. When we filed the Portland Archdiocese case, the oldest abuse claim was alleged to have occurred in 1938. We filed in 2004. So that's easy. You just go pull out the 1938 insurance policy out of a drawer, right? Well, that's not quite the way it works. So what if you can't find the 1938 insurance policy? How do you find out if you have coverage? There's actually a business called insurance archaeology. And insurance archaeologists will investigate old insurance policies, or they'll look in their own records where they keep old policies. And if they don't have the original actual policy, they'll have a template of a policy, or may have a template of a policy from that era. And accessing that information is critical, because then you find out who the carrier was, what the policy covered, what the limits were. And then you have the fun to trace and figure out who the insurer is today, because insurance companies merge, they get dissolved. And it's a whole special problem if the state takes over. We had to deal with something called the Oregon Insurance Guarantee Association, OIGA, which is run by the state to protect insured parties from dissolved insurance companies. So then figuring out from the policy what's exactly an occurrence is its own special challenge, but insurance is a very big deal. To give you an idea of how big a deal it is, the amount of insurance settlements in some of the Archdiocese and the Jesuit cases are as follows. In the Portland Archdiocese case, through mediation, we got $40 million. In the Society of Jesus case, through mediation, $118 million. In Davenport, Iowa, they got $19.5 million. And Milwaukee, while it may have won the trust fund case, it lost its insurance in pre-bankruptcy litigation. Their claims were not covered based on some state law decisions in litigation. So how are sexual abuse claims resolved in diocesan Chapter 11 cases? I mentioned earlier, there's three types of claims: known claims, unknown claims, and future claims. Again, future claims are people who've been abused but didn't know they have a claim, and we don't know who they are. Keep in mind, the main purpose of filing Chapter 11 for something like a diocese, or for any corporation, is you want to get a discharge in bankruptcy, which is defined as the legal extinguishment of an obligation. And that covers known and unknown claims. Any claim that arose prior to bankruptcy that the creditor gets notice of is discharged. So how do you give notice to people who you don't know exist? You need to comply with all the requirements of due process to protect both the claimant and the debtor. So what happens in these cases is we actually file two motions, two different types of motions. The first motion is to have the court appoint what's called a future claims representative, the FCR. And again, the future claimant tends to be a minor or someone who is no longer a minor but hasn't been able to connect the relationship between the claim, the event, and a claim, and has a claim for damages. So to give you an idea of how long a claim can be on statute of limitations for a claim, this is the Oregon statute, which provides that a person who is abused as a minor can bring a claim the later of 40 years old or the time that they see the causal connection between the event and damages. And this is the Ohio statute, which is 12 years after the age of majority, with certain exceptions for tolling, so it can actually be extended further. And every state has a different variation on the statute of limitations for childhood sex abuse. So the FCR is a representative of a group of people in an unknown number with unknown claims in an unknown amount. And the FCR has no client. You know, as lawyers, we have clients. We can say, hey, what do you think we should do? You make the call. I'm the lawyer. You're the client. Do it or don't do it. The FCR has no client. And that's a challenge. The second motion is a motion for a claims notification procedure. Because to comply with due process, we have to give people notice of these claims, and they have rights, and those rights have to be protected. Because you want to give them the right to file a proof of claim. So normally in bankruptcy, there's a 90-day procedure, a 90-day period of time to file a proof of claim. You get a notice, normally it's about 90 days, and if you don't file within the time frame, your claim is barred, the discharge would be entered at the end of the case, and the claim goes away. But in religious cases, it's vastly different than a typical commercial case. Commercial case, you know who your creditors are, you've got a list of accounts payable, you've got addresses, you've had relationships, you've talked to these people, and you sort of know what's going on. But not in these cases, not so much. So notice has to generally be, in the first instance, by publication. Normally, it's a national publication, be it the Wall Street Journal, New York Times, USA Today. And I think it's going to be really interesting going forward to see how social media, or notice by social media, is going to play out. In 2004 and 2007, I think, when we did the Jesuit case, social media was not nearly as prevalent as it is today. But I think I'm guessing, I don't know this for sure, but I'm guessing there'll be a push to use social media as a means of notice in the future. In the Society of Jesus case, we had a little different situation, somewhat extenuating circumstances. The Society of Jesus is organized into geographical provinces in the United States. And the Oregon province covered 5 states: Oregon, Washington, Idaho, Montana, and Alaska. Many of the claims we had involved allegations against Jesuit priests who were missioned to very northern villages or very small villages in northern Alaska. Many of the claimants were Native Alaskans. In the summertime, they would hunt and fish for sustenance, and so they would not be home. They'd be out in the woods or elsewhere for the summer months. And they don't generally get the New York Times, the Wall Street Journal, and USA Today in those locations. So how do you give effective notice? Well, in addition to the national and regional publications, we also published in newspapers like the Fairbanks News Miner and local village publications and more than 20 Native American publications in the Northwest. We posted notices in stores, in post offices, and in churches. We also used direct and indirect mail to give people notice that the bankruptcy was filed. If they have a claim, they have a right to file a claim and the form that they need to use and how to access it. And the court ordered about a 6-month period to file claims. And the court entered an order. It's a 53-page order on notice procedures. that laid out in detail every publication we had to publish in, how often we had to publish, when it had to be published, the maximum cost we could expend. And so we had a roadmap of what to do. And this was all negotiated between us and the committee that represented the claimants, the Tort Claimants Committee. But to give notice to unknown creditors, we actually published in newspapers like the Toledo Blade. And the cost of all that was something in the $600,000 range. So how do we get out of Chapter 11? How does a diocese, what's the exit strategy to get out? And how do you get out, and what do you get when you're done? As I mentioned earlier, the goal is a discharge, to be relieved of all liability for known and unknown claims. And to get through Chapter 11, there's a couple ways to go. You can litigate everything. You can litigate what is the property of the estate, what does the diocese own, what do the parishes own, and all the First Amendment issues that I mentioned before, plus many others. And you can take that all the way to the Supreme Court. And at some point, some of these cases probably will if dioceses go down this path. In Milwaukee, right now, the litigation is at the Seventh Circuit level, and they've been in Chapter 11 for 4 years, and they're not close to a plan. The parties can litigate all the sexual abuse claims, except you can't do that in bankruptcy court because the bankruptcy court has no jurisdiction to hear personal injury tort claims. So the bankruptcy court would have to send all of those cases out to state court all over the state, maybe not even in the state only. Maybe the claim, for example, in the Jesuit case, the claim might be tried in Alaska or Montana or Washington State. In the Portland case, what we ended up doing is we went to summary judgment. We had 3 summary judgment motions, 2 on property, on the real property as I was talking about earlier, and a third one on a $40 million perpetual endowment fund that was created by the diocese about 40 years earlier, which we did win. But we also started to develop a process to deal with the tort claims because they're entitled to jury trials. And the bankruptcy court simply has no jurisdiction to do that. So if everything were to be litigated, how long would it take? It would take years. The process is unwieldy, incredibly costly, uncertain, and really serves nobody. There has to be a better way. And fortunately, in the 2 cases we had, and in many of the other cases, what bankruptcy judges do is they appoint mediation judges. And in our case, we had 2. We had U.S. District Court Judge Michael Pogan from Eugene, a very, very well-known judicial mediator who's now retired, and Lane County, which is Eugene, Circuit Court Judge Lyle Velour. And what they did, through a very long process, is they were able to resolve all the insurance litigation. And the outcome of the insurance case is what happens in a plan in those situations is the insured, the diocese, we sell back our policies to the insurance companies. And they pay, in this case, I think they paid $40 million or something like that, if I remember correctly. The judges sat with all the claimants and with just a few exceptions resolved on a one-by-one basis almost every tort claim. They created a future claims trust, which we funded with $20 million to pay for future claims that would arise in the future. And there was a time limit and there was a procedure that was in place in the plan of reorganization that gave both us protection to the diocese and also gave rights to the future claimants. And all of the future claims are channeled into the trust, so the only resort they have is into the trust. And then the court, and we also, through the mediation and ultimately in the plan of reorganization, confirmed by the court, we got injunctions to protect the diocese from other claims. And that mediation took about 8 or 9 months of constantly being called by the judges. Howard, come to the district court, we need to talk to you, or they'd come to our office. It was a very, very interesting process that is all confidential but fascinating in the way it was handled and all that went on. The Jesuit, and that, I should mention, the Archdiocese case took about 3 years from beginning to end. In the Jesuit case, it was basically the same model as the Archdiocese case in the way it ended. Judge Paris appointed a mediation judge. She appointed Gregory Zive, who was a bankruptcy judge in Reno, Nevada. And Judge Zive did a terrific job. What he did is he resolved everything the way I just mentioned as far as the Portland Archdiocese case was concerned, but he didn't deal with claims. He resolved the insurance, the property case, all of that was done, but not the claims. So how do you resolve the claims? Well, and what's become the evolving pattern for these cases is the lawyers for the claimants develop a matrix. And the matrix will have a series of incidents that might have occurred to a person. And they relate, for example, the age of the abuse, the nature of the abuse, the frequency of the abuse, and a series of different factors that would apply. And the mediation judge will talk to each of the individuals and then give them a certain number of points, if you will, for each of the events that occurred. And so they total up all the points, and then each claimant has a certain percentage of the total points multiplied by the total number of dollars that are in the fund to pay those claims, and that's how much they get. And that was all confidential. I have no idea how much anybody got. I have no idea if some people got nothing. It's confidential, don't even know. But that's the way these claims seem to be getting resolved. That seems to be the pattern that is evolving. The Jesuit mediation took about a year of flying back and forth from Portland to Reno, or Judge Zive coming up to Portland, or phone calls, or long conversations. And sometimes, I think, in both cases, frankly, we had mediation. In the Portland case, we went to 2 or 3 in the morning once. In the Jesuit case, we were asked to leave about midnight, and I know that they continued well into the morning hours as well with the other side. So here's the question. Are there going to be more cases filed in the future? My expectation is yes, there will be. I've shown you the statutes of limitations for Oregon and Ohio. That gives you an idea of how long people have to file claims. Maybe decades, if not years. Many states are opening up windows of statutes of limitations. In other words, the statute's already expired, but the legislature has decided to open a window of time so that expired claims can still be brought, even though they'd previously been barred. Hawaii is an example of a state doing that. Other states are considering them. There's a lot of pressure, political pressure and other pressures, to do that, to create the windows or to modify statutes of limitations to give people more time to bring childhood sex abuse claims. And we'll know in the fullness of time who's going to file and who's not. We don't know today. I think the last one to file was Gallup, New Mexico, if I remember correctly. But unlike 2004 when we filed the Portland case, there are many more established laws and procedures. There's a body of case law now that's informative. There are lawyers with more experience in these cases because we tend to be repeaters, if you will. And there's different routes the parties can follow. And all that's helpful because we didn't have any of that back in 2004. But hopefully, with that information, that experience, these cases are going to be resolved more consensually, with less controversy, less acrimony, and less cost. And I'll tell you, the emotions that are in these cases are unbelievable. You know, in a commercial bankruptcy case, commercial Chapter 11, there are what I call economic synergies. There's a reason for people to work together. Because the supplier wants the debtor to survive, because that's the supplier's biggest customer. You don't have those economic synergies here. There's no ongoing relationship in the nature of a commercial case. And that changes things a little. When Congress passed the bankruptcy code and wrote the bankruptcy code, I don't know, 150 years ago, they had businesses in mind. They didn't have dioceses in mind. But somehow the code does manage to find a way to be maneuvered to work in a case that the framers, the drafters, legislators, Congress never thought about when they were drafting it. I want to leave you all with one last thought, and that's this. These are some, and I don't know if you can read this, some of the areas of law that we encountered in these cases. They range from bankruptcy law, the rules of civil and bankruptcy procedure, religious law, constitutional law, insurance, tort law, real property law, trust law, the law of charitable trusts, corporate law, contracts, class action litigation, equity, trial practice, negotiation, and mediation. And I know that many of you are law students going to class after this and saying, God, I hate this class. This is so boring. I am never going to use this stuff. This is the stupidest thing that I ever had to listen to. I hope he or she doesn't see me sleeping. Well, I can tell you, as having sat in the chairs you're sitting in and about to sit in, I felt the same way. And you just never know. You just never know when it's going to cross your path again. So I want to thank you for your time. I'm happy to answer questions if anybody has any. Yes?
Did you and the lawyers representing the claimants have different areas, some areas where you agreed rather wholeheartedly and others where it was much more difficult to settle things?
I think that the lawyers, intellectually understood what had to be done, and there were times when I would agree with my opposing counsel about an outcome, and we would agree, yeah, we've got to get there, but he or I would have a client problem, and we weren't quite ready to get there yet. So the short answer is yes, we would agree on things. There were things we just vehemently disagreed on. Fundamentally, we just couldn't agree on. I mean, I couldn't agree that canon law didn't apply in a church property dispute. And I think it does apply. The other side adamantly says it doesn't apply. Now, that we could never find common ground there. But could we agree on how big a future claims trust might be between us and say, yeah, it ought to be X dollars? And he would say, yeah, well, I can't get my client there, and I would say, I can't get my client there, let's see what happens. Sure, we would have those kinds of conversations. And I think for the most part, with a few exceptions, and there certainly were exceptions, we all got along pretty well. There were times we did not get along. And there were a number of times when I would say it was, between the lawyers, it was very contentious. But I thought I won't speak for every lawyer on the other side, because it would be untrue if I did. Everyone was professional. Yes?
Was there ever an argument to lift the corporate veil? Because I'm from Massachusetts, and the parish wanted to exist. The Archbishop said, no, you're not going to exist. Our bishop closed the parish, sold the property, and we reorganized things. So, in essence, can't you just lift the corporate veil and say the Archbishop, as a practical matter, you have absolute unfettered control over this property?
Well, that's a very interesting question, because the question of the Archbishop's control is kind of a two-edged sword. And in some of the cases, there's been conversation about, even if the parishes are separate corporations, that they should still be consolidated into the Archdiocese, because the diocese and the parishes are functionally controlled by the bishop. And you run into another interesting First Amendment canon law issue, because yes, maybe under canon law the bishop controls it, but under civil law he really doesn't. But then again, he might, depending upon how the parishes are structured. So we didn't deal with that because we didn't have those facts, but I think that issue and consolidation of the separate parishes into the diocese are issues that lurk out there depending upon how the facts might play out. Yes?
Do you know if during an open Chapter 11 case, does it have any effect on parishioners' behavior? Say, do offerings go down if there's a fear that it's all going to be taken by the bankruptcy case?
What we did in the Portland case, because we were the first and we were the only ones that did this, we convinced the court to establish a committee of parishes, parishioners, and donors. And their job was to represent the interests of that constituency of 354, however many hundreds of thousands of people, not just parishioners, but people who would donate to the church from time to time who weren't parishioners. And so the purpose of that, in part, was to try to maintain visibility for them and confidence that they would have that we'd be able to do the right thing for them. As far as, I think there probably was a decline, and I think probably in most cases there's a decline, but there's also a shifting of the donations toward more specific charitable purposes rather than just putting money on the plate on a Sunday. And I think there's just a change in behavior of the parishioners. People don't really know. People are scared. Many of the people that I met were very devout and just really gave their hearts to their parishes. And it was very, very hard for them to see this happening and to endure it when they really weren't involved, other than it was their faith and their church and their parish that was at issue. So I think the short answer is, yeah, there was some shifting. I honestly don't remember how it shook out at the end of the day, but I think afterwards, when we were all settled and done, things, whatever loss there might have been, was probably more than made up afterwards. Yes, Bill.
What is the order of magnitude of the difference between including parish property in the Archdiocese estate, and
Hundreds of millions of dollars. You know, you look at we had, as I said, 124 parishes, about 600 pieces of property. Some were pretty valuable, some were not. There's issues of zoning. You know, if you have a parish church, can that be a condominium if they tear it down and build a condominium instead? How much is it worth? What would happen to the property? Who's going to buy it? So it's hard to know. We never really did appraisals of all the property. The cost was prohibitive, but it was big dollars. I mean, there are some beautiful churches in Portland. I'm sure there are many beautiful churches in every diocese. Some particularly valuable just because of where they've been there for 100 years. You know, they may have been the only thing on the block. They may have started the block, and then everything built around them, and so their property is quite valuable. But the order of magnitude is very, very large. It's a game changer. Anyone else?
Has Portland done a restructuring since the bankruptcy?
What we did as part of the plan is we provided for a 1-year period of time for us to separate the parishes from the diocese and separately incorporate them. So as part of the plan, we had done that restructuring. And then if I remember correctly, we filed to protect the parish property from potential new claims against the diocese, post bankruptcy claims. We didn't want the parish property implicated. So we filed copies of stipulated orders in the deed records to show that there was an adverse interest claiming a right to the property in the name of the parish, in this case. So we provide either constructive or inquiry notice to somebody looking to protect the property from claims against the diocese. Yes?
There's a process by which priests get moved around. That's the hierarchical decision. And have there been any cases where someone in the receiving diocese has sued the sending diocese, so to speak, for having brought this person that knew about into the diocese, either within the U.S. or cross-border?
I don't know offhand cross-border. I think that there were probably claims made by, well, let me tell you what I do know. I know that I believe that in the Jesuit case, the Jesuit priests were missioned to the Fairbanks Diocese, the Diocese of Fairbanks in Alaska. And I think, I'm trying to remember, but I think that there were claims brought against both the diocese and the Jesuits by a claimant in Alaska for a missioned priest to the Alaskan diocese. And you get into some interesting questions about employment relationships between priests and dioceses and who's in charge, and it gets pretty complicated. But yeah, I think there may have been, but it's a good question and a fair one. One more question if anyone's got one, otherwise we'll, yes sir.
Going forward with mediation, be a lot of these cases are going to resolve. These other cases potentially be brought.
I think so. They're mediating in Milwaukee. I mean, the judge keeps throwing them back to mediation, and they're not coming back with a solution. Again, as I said, I think that the thought of litigating all these cases and the time, cost, expense, uncertainty, I don't know how it's going to work. I mean, what I told people about the case, they would ask me, how's this case going to end? I said, I don't know, but the elephant's going through the keyhole. I don't know how it's getting through, but it's coming out on the other end. And I don't know, in the case of a big elephant in a small keyhole where the people are not talking to one another and they can't mediate their way through and they have to litigate everything, I think it's going to create some real challenges for them. And I think Milwaukee right now is probably the test case for that because it's so acrimonious.
Please join me in thanking Mr. Levine for a fascinating talk.